11, my lord.
Recalling of witnesses. We'll allow it. What is the age of the Poxo?
Please, my lord.
Age of the victim, madam?
5 years, my lord.
Seriously?
Please.
Now what is the age of the victim?
No more. She is no more, my lord.
No more.
No.
What happened? 302 ಇದೆಯಾ? 302 ಇದೆಯಾ?
11 application.
ಯಾಕೆ 17 ಇಂದ ಮುಗ್ದಿಲ್ಲ ಈ ಕ್ರೈಮ್? Whatever it is, in a case of rape, Poxo, murder, if you take 8 years to complete the crime, where will they stop?
Correct.
These things should be done fast, sir.
But the law says it has to be done within 1 year.
So what? 7 years agide. Special CC 412 of 2017.
Yes.
We are in 2024. And all are heinous offense. The allegation is rape of a 5-year-old girl and murder. ಇದರಲ್ಲಿ ನೀವು ಕಂಪ್ಲೀಟ್ ಮಾಡಿಲ್ಲ, ಇನ್ಯಾವ್ದ್ರಲ್ಲಿ ಮಾಡ್ತೀರಾ?
The stage is already arguments, my lordship. They have filed. They
Many
approach the
times
court
recall
now.
application. Many times recall applications also seems to be.
How many times did you file recalling applications earlier?
Thanks.
Why did you not examine them? Law should not be misused like this to keep recalling the witnesses. ಯಾವ witness ಹೇಳಿದಿರಾ ಈಗ ಹೇಳಿ?
Lord, 8, 9, 19, 23,
9.
25, 26, 32.
ಅಲ್ಲ, ಇಲ್ಲಿ ಪ್ರೇಯರ್ ಇರೋದು ನಾನು ನೋಡ್ತಾ ಇದ್ದೀನಿ. ಅದು ಈಗ ಏನ್ ಕಾರಣ ಏನು?
They are all the material witnesses.
ಈಗ CW8 is PW6.
Please, my lord.
Have you not examined PW6 earlier? ಒಂದ್ ಸರ್ತಿನೂ ಆಗಿಲ್ವಾ?
No.
ನೆಕ್ಸ್ಟ್ ಯಾರ್ಯಾರ್ದು ಒಂದ್ ಸರ್ತಿನೂ ಆಗಿಲ್ಲ, ಯಾರ್ದು ಫರ್ದರ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಹೇಳಿ.
ಎಲ್ಲಾರ್ದು ಯಾವ್ದು ಫರ್ದರ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಆಗಿಲ್ಲ. ಎಕ್ಸಾಮಿನೇಷನ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಆಗಿಲ್ಲ.
ಯಾರ್ದು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಆಗಿಲ್ಲ? ವೈ?
That time, my lord, the advocate of the petitioner, counsel petitioner was not well.
Oh. Now the counsel is well?
Still.
Many times the cost was imposed. Cross examination. Your lordship may allow, my lord.
No, see, then tomorrow
Your
it will
lordship may allow, my
be allowed on the ground that they were not permitted to cross examine at all. I will give only one chance and direct the court to conclude the trial within the next 6 months or even next 3 months, because it is 7 years old in the case of rape and Poxo. And it's a 5-year-old girl. ಇದ್ರಲ್ಲಿ ಮುಗಿಸಲ್ಲ, ನೀವು ಯಾವ್ದ್ರಲ್ಲಿ ಮುಗಿಸ್ತೀರಾ ಸರ್?
3 months, my lord, with direction not to seek adjournment.
You are accused number 2. Why are you? He's in custody, is it?
No, my lord.
Then who is accused number 1?
He is number 1. Mallikarjun.
Again, against whom is the allegation?
Same.
Hello, madam. Allegation. Yes, Jagdish. Who is the accused, sir?
Mallikarjun alias Muga.
How are you involved in this? Accused number 2.
In her house only, the
A1 is Mallikarjun, A2 is Chandana. That is you. Where is your application? Objection ಹಾಕಿದ್ದೀರಾ?
Yes.
28. Page number 28.
The petitioner, accused number 2, is knocking at the doors of this court, seeking recalling of witnesses. Madam, ಇಲ್ಲಿ ಪ್ರೇಯರ್ಲಿ ಯಾವ ವಿಟ್ನೆಸ್ ಅಂತ ಇದೆ ಅದನ್ನ ನೋಡ್ಕೊಂಡ್ಬಿಟ್ಟು ಮಾಡ್ಬೇಡಿ. Recalling of witnesses so and so. In special case number 412 of 2017, arising out of crime in crime number 245 of 2017, registered for offences punishable under section 376(2)(I), 302 of the IPC and section 468 of the POCSO Act, read with section 75 of the Juvenile Justice Act 2015. The petitioner and accused number 1 get embroiled in a crime for the aforequoted offences on the ground that the accused number one had forcibly had, I'll can't say that. Forcibly had, page 5 alide. And the petitioner had threatened to kill the victim after the said horrendous act on accused by accused number one. The age of the victim at the point in time of the alleged incident was 5 years. The petitioner and the accused number one are charged of the aforesaid offences in crime number 245 of 2017. The police, after investigation, filed a charge sheet against these accused, and the concerned court registers special case 412 of 2017. 8 years, close to 8 years have passed by after the registration of the special case, after registration of a special C 412 of 2017, and the trial is yet to come to an end on notwithstanding the heinous offense alleged against the accused number one or the accused number two, as the case would be. The reason appears to be repeated applications being filed by the petitioner seeking recall of certain witnesses on the score that they have not been cross-examined, or they are required for further cross-examination. Two such applications had been allowed in the past, imposing certain costs. This is the opportunity was not availed of on the score that the advocate who was conducting the trial was not well on the said date. The third application is filed by the before the concerned court by the present petitioner accused number two, seeking recalling of the aforesaid witnesses. The application comes to be rejected on the score that it was only a ruse, RUSC, ruse to drag the proceedings. It is this order that has driven the petitioner to this court in the subject petition. The learned counsel appearing for the petitioner submits that the witnesses that are now sought to be recalled is for cross-examination and not for further cross-examination, as they have not been cross-examined at all. She would submit that it cannot be, the offense may be heinous, but it cannot be a case where there is no cross-examination of the witnesses at all. He would seek grant of one opportunity to cross-examine the witnesses on the date fixed by the concerned court and would not by the concerned court. The learned additional SPP would HCGP, learned HCGP would refute the submissions to contend that the trial is being dragged on one pretext or the other throughout, and in the offense, the offense being heinous and the facts being horrendous, the trial is required to be concluded expeditiously, but would admit the fact that these witnesses who are now sought to be recalled have not been cross-examined at all in the trial, owing to the folly of the counsel who had represented the accused in the trial, who did not cross-examine on the dates fixed for such cross-examination. I have given my source. The afore narrated facts are not in dispute, as they are all a matter of record. The petitioner is accused number two, who is said to have threatened the victim of any threatened to kill the victim of after the incident that has happened by the hands of accused number one. Therefore, accused number 1 and 2 are charged of the offences punishable and so and so. The facts are horrendous, the offences are heinous. The petitioner, the accused, filed 2 applications before the concerned court and 2 applications for seeking recall of witnesses and did not avail of the opportunity. In the normal circumstance, repeated applications would not be entertained, as it would become an abuse of the process of the law. But in the fact circumstance that the petitioner has not cross-examined the witnesses at all, as would reveal from the records, I deem it appropriate to grant one opportunity to the petitioner, and the cross-examination of those witnesses shall be completed on the dates on which they are fixed by the concerned court. It is made with a rider that the petitioner shall not seek any adjournment for further cross-examination of any of the witnesses, and no other application of the kind that is now presented before this court shall be entertained by the concerned court. The offense, as observed here and above, the offense is of the year 2017. The offense is of rape and the ingredients of POCSO, as also POCSO and murder, as the child with whom the accused number 1 had forced sex dies. In such cases, if the trial is not completed within the time that is prescribed under the statutes,
1 year.
i.e. the POCSO Act, 1 year, it would 1 year, it would become travesty. Therefore, I deem it appropriate to direct the concerned court to conclude the trial within 3 months from the date of receipt of the within 3 months after the cross-examination of the witnesses. How many witnesses are there?
9 witnesses.
9. The cross-examination of the witnesses shall happen on a day-to-day basis, i.e. 9 days from the date of its commencement, and no adjournment shall be granted to the counsel for the accused to for cross-examination. If in the event the accused would not avail of the opportunity, it is open to the court to proceed further in the trial. This is the last straw, STRAW, of opportunity granted to the petitioner. Is ordered accordingly.